the ruling that shifts the map. It's not often that a Supreme Court emergency ruling forces the entire country to stop and reevaluate how constitutional power works. But late last night, that's exactly what happened. In a 6-3 decision, the justices issued an order that immediately reshapes how federal courts can intervene in state policy, elections, immigration, public safety, and even Second Amendment litigation. For years, federal judges in certain courts have been able to freeze state laws nationwide with a single injunction. Practically speaking, that meant one lawsuit could halt the legislative decisions of major governments and affect millions of people who were never part of the case. With one emergency ruling, that era may now be over. It's already creating rapid political and legal fallout. Attorneys general are filing new motions, federal agencies are rewriting strategy, and governors are openly preparing to enforce laws that, until yesterday, were considered blocked. What makes this moment extraordinary is not just the ruling itself, but what it signals: a fundamental recalibration of federal judicial power, state sovereignty, and the boundary between rights and geography in America. And if the reaction in Washington this morning is any indication, this shift is only getting started. Chapter 1. The Emergency Order. The Supreme Court rarely rewrites procedure through the emergency docket, yet that's what they just did. By a 6-3 vote, the court held that lower federal judges no longer possess automatic authority to issue nationwide injunctions that apply far beyond the specific parties in a lawsuit. The majority leaned heavily on the historical record. Justice Neil Gorsuch traced the absence of broad injunctions back to the Judiciary Act of 1789, noting that courts at the founding only resolved disputes between the litigants in front of them, not the entire population. Justice Clarence Thomas added that Article 3 restricts judicial power to cases and controversies, not sweeping policy disputes affecting citizens who never entered the courtroom. To put it in modern terms, the ruling overturns 2 decades of practice where single judges could halt federal immigration rules, state election laws, or firearm regulations for the entire nation. Cases like Texas versus United States, 2016, immigration, and Washington versus Trump, 2017, immigration/visa policy, relied heavily on this mechanism. The emergency ruling does not eliminate injunctive relief, but it limits it to the plaintiffs themselves. A quiet but seismic procedural shift. Chapter 2. The Constitutional Twist. The constitutional theory behind this ruling is deeper than many analysts expected. Gorsuch's concurrence cites 12 founding-era cases where courts explicitly rejected requests for universal injunctions. Thomas's concurrence points to early federal practice showing that relief was always framed party-specific, not universal. What makes this historically important is that, for civil rights lawyers and modern litigators, nationwide injunctions were considered a normal tool. Yet, from Marbury versus Madison to Fletcher versus Peck, and continuing through the 19th century, courts did not step into broad regulatory enforcement. The dissent attempted to use Brown versus Board of Education enforcement cases as precedent, arguing that systemic discrimination demanded systemic relief. The majority countered by noting that those rulings involved structural desegregation under the 14th Amendment, not procedural power under Article 3. This distinction matters. It suggests the court is separating constitutional outcomes like civil rights from procedural authority like injunction scope, which sets up a long-term fight over what tools litigators still have. Chapter 3. The State-Level Fallout. Within hours of the ruling being published, state attorneys general began repositioning litigation strategies. Texas filed emergency notices in 3 immigration challenges. Florida did the same in 2 election law disputes, and Arizona referenced the ruling in a border enforcement case that had been stalled for months in the Ninth Circuit. This is not theoretical. It's operational. States are recalculating how they defend or enforce laws depending on the reduced reach of federal injunctions. In many ways, this mirrors earlier federalism fights seen in Prince versus United States, 1997, and Murphy versus NCAA, 2018, both of which emphasize that states retain sovereign power against federal command. But the most significant development is strategic. For 2 decades, both political coalitions relied on friendly district courts to halt opposing policies nationwide. With that tool gone, legal warfare becomes more fragmented, expensive, and slower. Chapter 4. The Litigation Strategy Shift. For advocacy groups, this ruling blows up the playbook. The previous system rewarded forum shopping into districts known for granting broad relief. Between 2017 and 2021, Nearly 80% of nationwide injunctions came from just 5 districts. Now, litigators must file multiple simultaneous lawsuits across different circuits to achieve the same practical effect. That means higher legal costs, longer timelines, and unpredictable outcomes. A similar phenomenon occurred after Shelby County versus Holder, 2013, overturned the Voting Rights Act coverage formula, forcing election lawyers to litigate voter restrictions case by case instead of relying on pre-clearance. The shift here is likewise procedural, not ideological, but the consequences touch nearly every policy domain. Chapter 5. The Immigration Frontline. Immigration is the area most immediately affected. ICE and DHS currently operate under more than a dozen injunctions limiting deportation, detention, and asylum rules. Under the new framework, many of those orders may only apply to districts where the plaintiffs reside, creating a geographic patchwork in enforcement. This directly mirrors Arizona versus United States, 2012, where the Supreme Court held that states cannot run their own immigration policies. Yet, ironically, the emergency ruling resurrects state-level influence indirectly not because states gain immigration authority, but because courts lose the power to freeze federal rules nationwide. Practically, this means immigration enforcement may vary drastically between states depending on litigation posture, a scenario the Department of Justice began preparing for within hours of the ruling. Chapter 6. Election Law Under Pressure. If immigration is the most immediate battlefield, election law may be the most politically volatile. Nationwide injunctions have been one of the primary tools for both major parties to halt voter ID rules, mail-in ballot procedures, ballot curing requirements, and early voting protocols. Under the new framework, those injunctions may no longer freeze state laws statewide, much less coast to coast. To understand why this matters, consider the operational side of elections. Administrators must finalize ballot printing, poll worker training, equipment distribution, and voter roll maintenance months before Election Day. A patchwork of geographically limited injunctions could produce different election rules within the same state depending on where plaintiffs filed suit. Historically, federal courts attempted to avoid such chaos. Cases like Purcell versus Gonzalez, 2006, established a doctrine that courts should avoid making late election changes due to voter confusion. Ironically, the new ruling could force earlier litigation, not to prevent ballot confusion, but because plaintiffs must now file in multiple jurisdictions to achieve the same protective effect. Both parties have relied on national injunctions for strategic advantage. Between 2018 and 2023, conservative groups secured 8, progressive groups 11. Removing that tool doesn't favor one ideology, it favors fragmentation. And fragmentation in elections is not a small thing. It raises fundamental questions about uniformity, legitimacy, and what the Constitution means when rights shift between counties rather than states. Chapter 7. Civil Rights and Constitutional Tension. Civil rights advocates are raising perhaps the most philosophical objection to the ruling. Their argument is simple. Discrimination is systemic, and systemic problems demand systemic remedies. Limiting injunctions to individual plaintiffs forces victims to litigate the same issue dozens of times before achieving meaningful relief. There is historical precedent for this concern. After Brown versus Board of Education, 1954, nationwide enforcement was necessary to dismantle school segregation, not because one plaintiff in Topeka needed relief, but because the constitutional violation existed across entire states. Under the new model, the NAACP Legal Defense Fund argues desegregation would have taken decades longer, one school district at a time. Disability rights groups point to similar challenges under the Americans with Disabilities Act, where injunctions often require systemic changes to public accommodations, transportation, or state agencies. Narrow relief risks leaving most disabled individuals unprotected while litigation churns slowly through separate courts. The Supreme Court majority did not resolve this tension. It sidestepped it. That omission ensures a new constitutional debate is now underway. When structural harm collides with procedural limits, which principle prevails? Chapter 8. Businesses brace for fragmentation. Corporate America may not speak in moral language, but it speaks in cost, and from that perspective, the ruling introduces significant uncertainty. Companies operating across multiple states could now face different regulatory environments depending on where injunctions survive. This is not hypothetical in the U.S. Chamber of Commerce estimates compliance costs could rise by tens of billions annually if firms must maintain different operational, environmental, or financial practices depending on the jurisdiction. Pharmaceutical companies are concerned about FDA and drug approval injunctions. Banks and fintech firms point to consumer protection rules. Technology companies face divergent obligations around content moderation and privacy. And healthcare providers could see insurance mandates vary not just state to state, but district to district. Historically, uniformity in commercial regulation has been reinforced through broad injunctive relief. Without it, economic federalism becomes messier. Some scholars liken this to the pre-New Deal era, when regulatory authority was heavily decentralized and litigation fragmented across circuits. That period produced enormous innovation, but also enormous cost. Chapter 9. The Supreme Court's institutional move. Behind the headlines and policy specifics lies a deeper institutional shift. By using the emergency docket rather than waiting for a full merits case, the Supreme Court bypassed extended briefing, oral argument, and lower court refinement. That is not just doctrinal, it's strategic. The court has increasingly relied on emergency orders to correct lower courts midstream. Statistical analysis shows a sharp uptick in emergency reversals in the last 3 years, suggesting a court more willing to manage federal litigation in real time, not just at the very end of cases. This echoes earlier judicial power assertion moments, such as Cooper v. Aaron, 1958, when the court directly reminded state officials that its constitutional interpretations bind all governments. Here, the target is not states, it's the lower federal judiciary. From a separation of powers perspective, observers are asking whether the court is tightening vertical control over the judicial hierarchy. From another angle, critics argue this is judicial overreach disguised as procedural reform. Either way, it marks a recalibration of federal judicial authority not seen in decades. Chapter 10. The Future Map of Constitutional Litigation. The most pressing question now is simple. What does this ruling look like in practice? Will injunctions become geographically narrow? Will plaintiffs multiply lawsuits across circuits? Will Congress intervene to restore uniformity? Will states assert sovereignty over contested policy areas? Recent history shows that procedural rulings can produce massive substantive consequences. Shelby County, 2013, reconfigured election law. Gill v. Whitford, 2018, altered redistricting litigation. Bruin, 2022, redefined Second Amendment case analysis. And Dobbs, 2022, relocated abortion litigation to state courts. This ruling fits into that lineage. It changes the terrain upon which rights are fought, enforced, and protected. Not because it decides what policies are constitutional, but because it decides how fast, how broadly, and through what mechanisms constitutional disputes are resolved. In that sense, the ruling's long-term impact isn't just legal, it's structural. It reshapes how America navigates division, disagreement, and constitutional conflict. And that shift will produce consequences far beyond the courtroom. The ruling is just the first move. The Supreme Court did not settle the debate. It initiated it. What comes next will involve state legislatures, federal agencies, advocacy groups, businesses, and millions of ordinary Americans who will now live under a more fragmented system of judicial relief. Whether that fragmentation produces innovation, chaos, or a new constitutional balance will depend on how quickly the legal system adapts. But the message from the court was unmistakable. Nationwide injunctions are no longer the default, and the era of single-judge national policymaking is closing. If you found this breakdown useful, make sure you're subscribed so you don't miss the next major legal shift. Like and share to help more people understand what just happened and what's coming next.